Hello, hello. It works.
You just want to make sure that the green one.
And over there on that one.
Good evening, everybody. Thank you for joining us at tonight's Southgate Planning Commission meeting. I'm going to be calling this meeting to order at 6:30 p.m. So now, Jimmy, can you do the Pledge of Allegiance?
Sure.
Thank you. Can we get a roll call? Present.
Let's try it again. Chairperson Ruiz,
Present.
Vice Chair Prieto,
Present.
Commissioner Castañeda,
Present.
Commissioner Osaeta,
Present.
and Commissioner Valenzuela.
Present.
So now,
No, sorry. Who's going to read the report on posting?
okay.
I, Javier Barraza, Special Projects Coordinator, certify that a true and correct copy of the foregoing meeting agenda was properly posted on August 14, 2025, 72 hours prior to the scheduled meeting as required by law. So we're moving on to consent calendar. The Planning Commission will consider approval of the minutes for regular Planning Commission meeting of November 19, 2024, and June 18, 2025.
So now for the first item under the consent calendar, Planning Commission meetings for November 19th. Did all my colleagues here have time to go through them? Does anybody want to submit for their approval?
I had time to review them. I just had a question for the November 19th minutes. Did we not approve those before?
That's correct. I know it's been some time. We apologize for that, but we had some changes during that time, that period, at the end of the year. And so they just sort of got delayed, and we're bringing them to you tonight for for official approval.
Got it. Thank you.
Does anybody want to make a motion, or does anybody have any other questions or clarifications or edits?
I can make a motion to approve.
Can I get a second?
Second.
Do we need a roll call?
Just to be clear, the motion is for the minutes of November and June. So we carry
That's
a
correct.
motion-
For November 19th and June 18th.
I think so, right?
Commissioner Castañeda?
Okay.
I have a question. I wasn't
okay.
here for the November 19th, so
You can abstain.
abstain.
You can abstain if you want. You technically don't have to have been here, but you're free to abstain. We've got enough folks that will.
Okay,
pass it.
I'll abstain.
Commissioner Osaeta,
Yes.
Commissioner Valenzuela.
Yeah. Again, as long as you are comfortable that the city staff has accurately transcribed it, you're not prohibited from voting yes just because you weren't at the meeting.
Yes.
Chairperson Prieto? Oh, Vice Chairperson Prieto
Yes.
and Chairperson Ruiz.
Yes.
Motion passes. Moving on to the public hearings. Item A, zoning code amendment to modify Title 11, Chapter 11.43, accessory dwelling units and accessory structures of the Southgate Municipal Code, and finding the action exempt from the California Environmental Quality Act.
Chair Ruiz, we do have our Associate Planner Valdez prepared for a presentation, if you'd like.
Yes, can you please present?
Yes, they're loading up the PowerPoint right now. Good evening, Commissioners. My name is Joshua Valdez, Associate Planner for the City of Southgate Planning Division, and I'm here to present to you the proposed zone code amendment to the Southgate Municipal Code, Chapter 11.43, titled Accessory Dwelling Units and Accessory Structures. In January 2021, the city adopted Ordinance 2021-01-CC to establish Chapter 11.43 of the Southgate Municipal Code, which allows accessory dwelling units, ADUs, as required by Government Code Section 65.852.2. Since then, the state law regarding ADUs and JDUs has continued to be modified as new bills are signed into law by the governor. These include Assembly Bill 345, Senate Bill 897, Assembly Bill 976, Senate Bill 477, and Senate Bill 1211. Over the course of this presentation, I'll be discussing how these state bills require staff to make amendments to the existing ADU code to ensure it is aligned with state requirements. So, starting with Assembly Bill 345, it amended Government Code Section 6585.2.62 to allow for the separate conveyance of an ADU under specific conditions. This applied only if a qualified nonprofit corporation is involved in a program that enables low-income families to buy the ADU with a no-interest loan to a qualified buyer. It also requires the definition of qualified nonprofit corporation and qualified buyer to ensure these specific criteria are met. Senate Bill 897 amended the state's ADU government code to require municipal codes to only impose objective standards on ADUs that include but not limited to parking, height, setbacks, landscape, architectural review, maximum size of a unit, and standards that prevent adverse impacts on any real property that is listed in the California Register of Historical Resources. Assembly Bill 976 amended Government Code Section 65.852.2 to remove the owner occupancy requirement for new ADU applications submitted after January 1st, 2025. This change limits the city's ability to impose restrictions that require the homeowner to live in either the main house or the ADU. Senate Bill 477 reorganized and clarified existing state laws regarding ADUs and JDUs, previously covered under Government Code Sections 65.85.2.2, 65.85.2.22, 95.852.23, and 65.852.26. ADU regulations are now consolidated under Section 66310 through 66342 of the Government Code to improve coherence without substantive changes to the regulations. Senate Bill 1211 amended Government Code Section 66323 to require municipalities to amend their ADU ordinance to allow up to 8 detached ADUs on multifamily parcels, provided the number of ADUs does not exceed the number of units on the lot. So, staff has incorporated these bills into the various sections of the Municipal Code 11.43. As mentioned, Senate Bill 477 reorganized the existing ADU state law under Government Code Section 66310 through 66342. Southgate Municipal Code Section 11.43.10 through 11.43.60 has been updated to reflect the appropriate government code sections. Similarly, Southgate Municipal Code Section 11.43.2020 was updated to amend existing definitions and add new definitions to be consistent with Government Code Section 66312. Some of the amended definitions are for efficiency unit, livable space, and lot coverage, while adding definitions for qualified buyer and qualified nonprofit corporation to be consistent with AB 345. Southgate Municipal Code Section 11.43.30's verbiage was amended as it relates to setbacks, location placement, parking, height, architectural review, maximum size of a unit, and to allow up to 8 detached ADUs on multifamily properties, provided the number of ADUs does not exceed the number of existing units on the lot, consistent with SB 897 and 1211. Southgate Municipal Code Section 11.43.040 was amended to align with Government Code Section 66315, 66333, and 6341. These changes consisted of amending the verbiage regarding non-conforming conditions, minimum ADU size, and JADU deed restriction requirements. Additions were also included to this code section, in particular verbiage outlining the criteria needed to be met so an ADU may be sold or conveyed separately from the primary dwelling. Southgate Municipal Code 11.43.050 was amended to align with the Government Code Section 66314, 66321, 6323, 66324, and 66315. These changes consisted of amending Southgate Municipal Code Section 11.43.050 to align the allowed floor area of an ADU with the state minimum required setbacks, increase the height limitation for ADU, and parking requirements. The amendment also includes codifying existing planning practices that allow for the expansion of an existing accessory structure located on parcels with a single-family dwelling up to 1,000 square feet, and adding architectural design standards to ensure that ADUs are architecturally compatible with the existing primary dwelling. The verbiage contained in Southgate Municipal Code Section 11.43.60 regarding the ADU review process was amended to be consistent with Government Code Section 66314 and 66320. This is the last section of the ADU portion of Southgate Municipal Code Section 11.43. There is one additional section contained within the chapter regarding accessory structures. Staff thought it appropriate to make a minor adjustment to Southgate Municipal Code Section 11.43.070 regarding the height of detached garages. The code has a height limitation of 10 feet, which has made it difficult for some applicants to accommodate a garage with a pitched roof, leading to some garages being proposed as flat roofs. As such, staff is proposing to amend this code section to allow garages to have an additional 2 feet in height to accommodate a roof pitch that is aligned with the roof pitch of the primary structure, bringing the total height allowed for a detached garage to 12 feet from grade to roof pitch. Staff recommends Planning Commission accept the determination that the proposed zone change amendment is exempt from California Environmental Quality Act, CEQA, as a ministerial project pursuant to CEQA Guidelines Section 1526-8A, and adopt resolution number 2025-07 regarding approval of an ordinance to council to amend Chapter 11.43, accessory dwelling units and accessory structures of the Southgate Municipal Code. Thank you. That concludes my presentation.
Thank you. Is there any public comments or anybody in the public? Seeing none, I'll move to my colleagues. Does anybody here have a question?
I have a question for staff. Do we know when the last time this was amended?
2021.
Any other questions? No. No, you go ahead.
I was trying to gather my thoughts here. I think one of the things that I think has been really beneficial, I can only speak for myself, I can't speak for my colleagues, is that, you know, anytime something like this comes up, you guys are the experts in this area, and it would have really been helpful to get like a study session on this process. That kind of gives us a better idea of like how to navigate that. I know it's what we've done this in the past, where we have some study sessions for items that don't typically come to us, especially foreign things. Like, this is your world, we're just visiting. So I always refer to you all like, hey, you guys are the experts in this. Whatever you recommend, you know, I always lean on your expertise. But I think for me personally, I think that would have been really helpful, It's stuff we've done in the past for other items that come to the commission.
You know, if I can say, as to the mechanics of this whole thing, Sacramento likes to encourage housing, and every time you turn around, it seems like they're passing another law amending how cities are required to deal with ADUs. And this is really just a catch-up session where we're explaining, here's how the law changed. We need to update our municipal code so that it aligns with the law, which Sacramento insists that we do. As far as the nuts and bolts of what these provisions that you're adopting actually require, I think we all have studied ADU law ad nauseum. So if you want a session on what the city is and is not allowed to do when somebody presents an application for an accessory dwelling unit, I'm sure we'd be happy to put one of those on for you, because we could probably do half of it in our sleep after all of this exercise.
No, thank you. I think one of the reasons I mentioned, because it seems like in some of the presentation, there's areas where staff has some freedom on like what, some leeway on how you can, in this case, increase the height by 2 feet. How many, I guess one of the things that came up.
That was actually not for accessory dwelling units. That's it's like 90% of the chapter is basically parroting state law on accessory dwelling units. But there's the last section in the chapter is just for things like tool sheds and standalone garages. And so we have much more flexibility on that.
So maybe, I guess the question is, how many ADUs per lot does this draft permit, and how does that compare to what the state law requires?
It permits exactly as many as state law requires. And while we have freedom theoretically to go beyond that, I think staff chose not to, because physically there's not really room on the average Southgate lot to do it. And it differs depending on whether there's a single family residence on a lot or a multifamily residence on a lot, because you're legally allowed to squeeze more ADUs onto an apartment site than you are onto a single family residence. Generally, the maximum you could do on a single family unit, if you're going to subdivide it under SB 9, you could take a single family unit and wind up with four housing units on the single family lot. Typically, you're only going to see on a standard lot, you're going to see one exterior accessory dwelling unit and then potentially one interior junior accessory dwelling unit. But that would be about the maximum that an applicant would have the right to have, and that would kind of be subject to the size of the lot.
So if we have, this is just a question. This is your world, right? But if there's a flexibility on the square footage of the ADU, would we lean towards having something a little bit smaller, given that it might have, it would allow us to maybe mitigate some of the parking issues that we have in our city, right? So if we maximize the space of the ADU based off of the square footage of the actual lot, then in some cases it can potentially impact our ability to have on-site parking.
We're fairly constrained by the law. We can't, a junior ADU cannot by definition be greater than 500 square feet. An accessory dwelling unit can, just a standalone unit can be limited to 850 square feet. If it has one bedroom or less, it can be limited to 1,000 square feet if it has 2 or more bedrooms. But the state doesn't give us a lot of leeway, and we can't condition the imposition of or the creation of an ADU on establishing an extra on-site parking space, unfortunately. So like I say, that Sacramento is of the opinion that all of California's problems will be solved if we build more houses, and they know that cities resist that because of problems like Southgate's parking problems. And so they have given pretty narrow guardrails to us, and we've exercised what little flexibility we have under state law, and staff will have some discretion when an applicant comes forward, but we can't say, no, you can only have a 400 square foot ADU, or you have to have 3 new parking places. State law doesn't allow things like that.
No, makes sense. Yeah, because I was looking at the California Department of Housing and Community Development, the Accelerated Dwelling Unit Handbook, the January 2025 one, and I was looking through that, and it had a ton, as you can imagine, it's just a ton of information, right? So I'm like, I think this is like beyond me. So I'm like, I need to come back to you all and just ask some basic questions, because I'll be reading packets, and it only makes sense for folks that live in it.
It
So-
shouldn't be beyond you. If the law requires a lawyer to interpret it, then it's a bad law.
So that's actually a really good point. So when we're putting these resolutions together, is it an opportunity to provide clarity to the greater community in regards to what our staff have to navigate within this?
The agenda bills are intended to do that. That's sort of be a brief summary. When you get a 100-page packet, the agenda bill is intended to be a summary that allows you, before you dive into that 100 pages, to read in a page and a half what this is all about. Maybe we're not doing a good job, and I guess we'll have to try to be a little clearer in future.
I've just figured that we have access to you all, right? And I'm assuming there's a lot of community members that I don't know how much, well, I don't know if this even requires any kind of community input in the process in regards to how it's formulated, or what, I guess the input that you all got was, hey, we have community members that are having restrictions based off of the height of the potential ADU or whatever was being built, right? Is that where you have then kind of created some additional variance to accommodate that?
So in regards to ADU height, there's not really much leeway that the state gives us. So the difference is in the recent iterations of the state code, they give different scenarios which allow for varying heights. However, we didn't touch the heights for this other than what the state required. Some things that we implemented were allowing for the new construction of a JADU. So currently, as the state code reads, a JADU has to be part of the existing primary dwelling. So for instance, if you have a 2-bed single-family dwelling with a den, and you say you want to convert the den, that is okay and appropriate to go ahead and do. However, let's say you just have the two-bedroom home and you want a JADU, the city will allow you to construct a JADU up to 500 square feet. It's technically in addition to the home, but to avoid additional fees on the applicant, we classify it as a JADU once it's been approved. So it was more so being a little bit more lenient to allow for the development of ADUs and JADUs in certain parcels where they wouldn't be allowed to, or they would incur an additional expense that may be a burden to them.
Thank you. Sorry, Gabriel, you're stepping in and I was kept speaking and you just kept doing a limbo there.
I was just going to add too, I think the comments you make are very good. I think at the end of the day, if the Planning Commission was to adopt this, we want the public to understand this as easy as possible, right? There's a lot of language in there, a lot of acronyms they use in there that do people understand this all the time. So it would be good to hear from you, kind of like how you think this could be best presented to the public, things that you've seen. Is it visualization of what this could look like? Is it information on the website that has less kind of the law speak, right? And more something that is accessible to the public. So please share those ideas with us, because we value what you have to say about that.
Yeah, and
Thank you, Gabriel.
I think that's a good point. And I think some of these attachments provided were really helpful. I had mixed feelings about the redlined document because I don't know, my mind likes to kind of, read first and then comprehend later, and then I have to go back. So it was kind of hard to kind of mitigate some of that. But I think it was really helpful to see what the changes were in comparison to the old verbiage. And from that, I did get a lot of my questions. And like something that came up was the selling of the ADU. I didn't even catch that or understand that portion of the document. And so I guess this is one of the questions I have after the presentation is, how is that going to affect the parcel? Is it going to be something that's similar to a condominium, or is it going to have its own parcel? Is it going to be sort of parceled out? And I actually have quite a few issues or questions. And they kind of stem related to things that I've seen mentioned brought up during council meetings, in particular with parking. The parking section was pretty clear about some of the changes. And I know that that has been an ongoing issue, and it's also kind of brought upon this problem with ADUs within, the city of people who don't want them or aren't open to them because of the parking issue. And so my question is, one, why is there verbiage around not, or can we simplify or promote or do something to promote ADUs that are on top of parking? Because I think there was a section that kind of singled that out as not an ADU. Is there a reason? Is it some just because it doesn't fit a definition of an ADU?
So, if I could add a comment, so in regards to your first part of your question for the separate conveyance of ADU to someone else from the primary dwelling, there's so let me organize my thoughts. So there's only specific criteria that need to be met in order for someone to sell their ADU separate from a home, and it would be conducted similar to a condominium sale. So you have to be a non-profit corporation, building the ADU, and then the person you sell it to has to be a quote unquote qualified buyer, which is a low income member of the community. And so if you meet those two requirements, then you are able to sell your ADU separately from the primary dwelling. That's the only circumstance that you would be able to convey it separately. From my time here in the city of Southgate, I haven't dealt with any nonprofit corporations building ADUs. They all mostly have been for-profit or regular mom and pops.
Yeah.
So that's in regards to the separate conveyance of an ADU in regard.
So just to add to that, so what about the feasibility? Because I think there was a section about utilities and whether or not there's a requirement for these ADUs to have their own separate utilities from the primary residence. And I don't think it is, right? They're only required to have their own utility, like let's say meters, if they're built when the primary residence is built.
So you are allowed to separate your utilities. It's not a requirement. Correct me if I'm wrong, Craig, but it's not a requirement. It's just a choice. There is verbiage that was added into this new iteration of the ADU code talking about utilities. But for the most part, that wouldn't affect our residents here, but feel free to interject, Craig.
Yeah, it's the law is written to give the homeowner flexibility. If the homeowner wants to separately meter the ADU from the primary residence, he can do that, but he's not required to do that, and the city can't require it as part of the ADU application. And as far as the sale of ADUs separate from the primary, the ADU law prohibits the city from requiring things, but there's also the Subdivision Map Act, which requires certain subdivisions before properties can be sold separately. So a homeowner who wanted to do that is going to have to navigate those laws. And also SB 9 that was recently passed that talked about the subdivision of property. They made it clear that you can't reapply those laws over and over and over to slice up a single family lot into 10 different lots. You're going to be limited to 4 at the most. So ADUs are good, but you're not going to find yourself in a situation where you've got 15 ADUs on a single family lot.
Yeah, I guess my question just had to do with how it would make sense to subdivide or sell an ADU if the utilities are connected to the primary residence.
Well, if you wanted to sell it separately, then I think that would be a situation where the city would require
Okay.
in order to issue a certificate of occupancy, I imagine to the new individual owner, the city could require the same types of health and safety requirements that it requires for other houses, and certainly being able to, I mean, especially with water bills, since so many of the city services are billed to the water company, requiring in that situation a separate meter to the ADU that was going to be sold separately would be within the city's power.
Okay, so they would be able to make sure that happens. That's good to know. And as far as the parking issues, I don't know. Yeah,
So-
well, you still have to address that.
So the current iteration of the code does not allow for, quote unquote, 2-floor ADUs, essentially for their ADU to be placed above your garage if your existing primary dwelling is in 2 feet. The code reads along the lines that the height of the ADU cannot exceed the roof line of the primary dwelling, if I'm not mistaken. However, with the new state bills, that is not an enforceable rule. Now, for predominantly most of the city, it is 18 feet because the majority of the city is within a half a mile of a high quality transit spot. So the state allows for a higher height. And with that, they also give them a 2-foot, what is the word I'm looking for? Grace or extension. So essentially a 20-foot ADU with the 2 feet accounting for the roof pitch. That's where staff got that verbiage from for the accessory structures at the very end. So now with the new iteration of the code, individuals can propose to place their ADU on top of their garage without the primary home being 2 floors. So hopefully that does encourage more 2-floor ADUs with retaining the garage on the ground floor and building up. I know the current iteration of the code was before staff's time, so I'm not exactly sure what the thought process was behind not restricting that type of development. However, new state laws have essentially removed that restriction.
No, that's great, and maybe that section needs to be clear because that's not what I got out of when I was reading it. But I think that would definitely help with a lot of the parking issues, and homeowners might even be up for that because I mean, in especially because a lot of these are homeowner occupied. You know, I see them all fighting for parking down my street too. So hopefully this is something people consider. And then the final question I have is related to collection of fees. I think that it was very specific about what kinds of fees can be attributed, and I don't know if this would have been a good opportunity to kind of include some fees that the city is in dire need of, especially when they have to deal with utilities that the city provides, like water, like street usage, street wear and tear, and even park use. I know that would have to be part of some sort of ordinance. Would that be something that can be kind of passed with this, or would that have to be its own thing?
It's not on the agenda, so we really couldn't take an action recommending any increased fees to the city council. That's a subject for a different council or planning commission activity. Normally, assessment of fees is not within the purview of the planning commission. You are typically tasked with regulating how property may be used and not so much how the city pays for the services that it renders. In this particular case, the matter before the commission is simply modifying the ADU chapter of the zoning code so that it aligns with state law. To the extent that the state ADU law governs fees, it's typically telling the city that they can't charge extra fees because they're afraid that adding additional fees might discourage ADUs, which the state is trying to encourage. So Yes, it's a good thought. No, we can't add that to this particular item.
Yeah, because I know that the utility connections and fees section, would that, in essence, limit that in the future?
So yeah, the new section added is essentially limiting the city's ability to implement impact fees essentially, or fees for ADUs less than 750 square feet. However, it does say that impact fees does not include any connection fees or capacity charge charges by the city or any local agency, special district, or water corporation. So it does seem that there are like connection fees,
Yeah.
essentially, like if you're proposing a new sewer line or a new utility line, there seem to be fees associated with that. But if they're sharing the same line and it's less than 750 square feet, it really restricts our ability to impose any fees on these on ADUs specifically.
Got it. Thank you. Those are all my questions. Anybody else?
Chairperson Nazareth, I just like to add, lot of good comments, questions being said. But I wanted to add that, it has been a while since we updated our ADU ordinance. I guess 2021 was the last time. And as you saw from Associate Planner Valdez's presentation, there's new laws coming out all the time, just about every year. And so other cities have been updating their codes almost like on an annual basis. And so we are sort of playing catch up with that. There are chances that there are new bills that will be released or adopted this year that we'll have to update our code in another couple of months. So to Commissioner Zeta's point, having like a workshop, yeah, that is possible. Maybe if we have time, we can maybe present that the next time we do an update. But sometimes these bills go into effect and almost immediately. And I know other cities that do urgency ordinances where they can't get it in time, doing the whole noticing process. So I do an urgency ordinance so that they have an urgency in place, pretty much immediately. And then they go back and they do the proper steps to update the ordinance, adopt it properly. But certainly, yeah, in the future, we can consider if we have the time to be able to present like a workshop or a study session with the Planning Commission to let you better understand these, the new laws that are changing. And again, because it happens almost on an annual basis, it is likely that we'll have to update it in the next several months or so, to once again be up to date with state law.
Yeah, that would be great to get us all on the same page when it comes to these, especially if they're going to be coming back pretty soon. But I guess that's it for the public hearing portion, unless anybody has any other comments.
Quick question, just one, maybe two questions, and I'm done. Just because of the resource, I might as well use them now. Might as well get to it. Is in regards to this ordinance, I know there has been adjustments. When was the last ordinance? When did that come out? Was that January? Was it November of 2024? The one that the adjustment by the state.
That'll be SB 1211, and that went into effect January 1st, 2025, which
Yeah.
allows up to the 8 detached ADUs on multifamily parcels.
And then there was one
In
last
December.
year that took effect mid-year.
Yes.
And then SB 9 and SB 5, I think, took effect at the beginning of 2024. So, like I say, it's hard for us to keep up with.
Yeah, no, I'm noticing. Yeah, I mean, so what is like for the city, since you guys navigate this? What is like maybe the grace period that we have, given that if this came out in January 2025 and now we're in August, like what's the typical turnaround time for cities to make these adjustments so that we can technically be in compliance with our?
Yeah, I want to say the last bill was adopted late 2024 and went into effect January 1st. So cities only got maybe a few months at the most to update their ordinances. For the most part, the state's making it easier to build ADUs, every time these things pass. I think one of the more recent ones was if a city wanted to deny an ADU, the city has to make certain findings to be able to deny it. It's not just a simple denial. It's like another step in order for cities to deny an ADU.
So do we have a time frame of like when we have to say update an ordinance, given the changes at the state level? Do they give us 5 months? Do they give us 6 months? What's
They,
effective practice? on that?
it depends on how quick the legislators are to adopt the ordinance. Most ordinances will take effect on January 1st.
Ah.
So if they adopt, I mean, most statutes will take effect January 1st of the following year. So if they've got their act together and they pass a particular ordinance regarding ADUs in March, then we get 9 months to apply it. If they pass it in November, then we've got a few weeks.
Yeah, that would make sense. So that was my one question, right? My second question is I heard from residents that our city has allowed additions as part of the auxiliary structure conversions. Is that required by law? The existing for existing space? And can you clarify if we allow that expansion in these cases?
So in certain situations, we do allow for the expansion of an accessory structure. It's predominantly in parcels that have a single family dwelling. So that is one of the staff planning practice that is being proposed to be codified. So let's say that you have an existing single family dwelling with a detached garage, 2-car detached garage, roughly 400 square feet. Our code allows for up to 1,000 square foot ADU. So as part of your ADU conversion, garage conversion, you would also be allowed a 600 square foot addition to a max 1,000 square feet so that you could maximize your build out essentially. So yeah, that would be my response.
Thank you. Oh, that's it. I promise.
Thanks, everybody. Do we need a motion to accept the determination for CEQA? Can I get a motion from any of my colleagues?
Motion.
A second?
Second.
Roll call?
You know, actually, that is part of the overall resolution.
Oh,
It includes, so it's really just one motion
for
to
both.
accept the resolution, which essentially includes the determination that it's exempt from CEQA and recommends to the city council that it upgrade the zoning ordinance.
Alrighty, so can I get that motion then?
Can I motion?
Second the motion.
Commissioner Castañeda,
Yes.
Commissioner Osaeta,
Yes.
Commissioner Valenzuela,
Yes.
Vice Chair Prieto,
Yes.
Chairperson Ruiz.
Yes.
Motion passes. There's no open session items. And we're going to open it to public comment. We did get an email from Mr. Dominguez. For the record, we summarize it because we have to stick to the 3 minutes. But I gave the commissioners a full copy of his comment. So Mr. Dominguez states that at the July 10, 2025 Parks and Recreation Commission meeting, it was revealed that Southgate has never collected Quimby fees because the city council never passed the required ordinance. Missing out on over 50 years of park funding, he urged the commission and Mr. Perez to push the council to adopt the ordinance, calling this a clear example of poor city management and emphasizing the need for leadership to prioritize this issue. And if there's any comments from city staff?
Well, the only thing that we would like to report, I actually attended the USC Lusk Neighborhood Data for Social Change yesterday. And it was a presentation to give the state of LA County Housing and Neighborhoods report. That report is available for the public. It's free. It's at la.myneighborhooddata.org. And it's data collected for LA County on the changes to housing and neighborhoods. In case the commission or the public is interested, I can also email a copy or that link over to the commissioners if you're interested. That's all.
Thank you. Any public commission comments?
I did, I just want to make sure I recognize, Gabriel, thank you for that presentation. It was at the Rec and Park Commission, so it was actually very informative. It would be great to see if we can get that presentation here in front of the Planning Commission. I think it definitely would be very informative for us. I felt it was, I mean, you're on the commission, so I thought it was very, very well done. And do we have an update on how that's coming along, and like where we stand regarding the Quimby fees, given that it was a question by a resident? Is that something that we can at least get an update on?
Right now, the impact fees are being studied right now, so there's a study going on. That is one of the fees that's being examined, so it'll be up to the city council if they want to consider that when it comes back to them. But yeah, I think it may happen. Yeah.
Great, thank you. Any other comments?
Just want to say thank you to staff for putting package together. Like Jamie mentioned, we're a little green on this. So it's very helpful to have the summary of changes and what was the revision. Thank you.
Well, Associate Planner Valdez and our Assistant City Attorney Hardwick worked really hard on those, so appreciate their work on it.
No, it was really helpful. And yeah, that presentation, the Quimby fees presentation was good. And I really appreciated the additional information related to the other, possible revenue sources. And I think that definitely helped, especially coming in to the budget process that the city went through and having that knowledge already. I think it was really helpful in scrutinizing or even being able to give ideas for the budget. But I think one thing I had a question about, or a couple of questions that came to me related to the more recent city council meeting. One had to do with the issue that the city council voted on related to the flagpole permit. And I think Councilmember Rios asked why it didn't come through us. And so I just wanted to see if it was an issue that, or what that reason was. I didn't really understand why it didn't happen. Not to say that well, I mean, if it's part of our job, and then what kind of separates that from other issues. And the other question I had was actually more of a set of questions related to something else that came up during the meeting. And I brought it up to John, and I don't know if you were able to get any answers related to the UWS transfer station and the Green Waste Systems transfer station. For my colleagues who hadn't had a chance to listen to the council meeting, a complaint came in related, or public comment came in related to the odor. And I'm not sure if it was mentioned then that there's also been dust complaints related to the site. My familiarity with the issue goes back to maybe 10 years when I was part of the Southgate Community Environmental Health Action Team. I know that was something that was brought up, and I kind of remember it, or thought I heard it was being resolved. So I was surprised to hear that that's still been an ongoing issue. And more so that there's concerns about whether the city is in compliance when relaying the odor complaints to the other regulatory agencies that have oversight. And so I don't know if you all have any jurisdiction in that, or if that's something that's more related to Public Works. But, seeing as to how they're part of our community, they're a service provider, and they seem to be really invested in our community. I just hope that that's something we can encourage our city to really make sure that, they are a good neighbor, because they are our neighbor, and they have been for at least, as long as I've been living here. So I don't know if you had any answer to that.
I can try to answer some of the first question in regards to the flagpole over FHC. We did a modification to an approval that we did, I guess, late last year, earlier this year, where they did a modification to that building. They recently occupied that building. They moved in. They did some tenant improvements and some exterior improvements to the building. They also improved the parking lot areas, the outside areas. And so we reviewed that earlier this year and gave them approval. The building was signed off earlier this year. There's still some structures in the back that still need to be reviewed and approved, which Building and Safety and Public Works is working on. There's also some, I guess, some street improvements along the front that Public Works is requiring. So that's currently going on. We consider this one on modification because they came in, I guess, after the approvals, and they wanted to put a flagpole there. It would remove 2 parking spaces, but they were already, at least on plan, showing they had more than enough parking spaces, 10 over the requirement. And so it really was a judgment call. The way the code reads is the director has a determination to either bring it before the Planning Commission or the City Council. Because this was considered, I guess, a statement or landmark that FHG wanted to have, we thought it would be more appropriate for the City Council to review. There was also a tour done a couple of months ago that City Council was able to visit the site and take a look at the facility. And so since they were familiar with it, we felt it was best that they review the flagpole. And just because of the height nature of the proposal, it's similar to the flagpole over the Schultz Steel property to the east along the freeway, the 710 freeway. And that's really the reason why it went to City Council.
Got it.
So in regards to the UWS facility, I understand, I guess they have at least two facilities in our city. One, they had a building on Imperial that was demolished, from what I understand. There was a lot of problems with that building. It was a nuisance. And so they eventually demolished that building. So I'm not sure if that was the structure you're talking about or another one. Okay.
I think if it's regarding like there's been some odor complaints that the city has been receiving complaints on. So code is addressing it right now. We're also logging the complaints. The facility is on property that the city leases to UWS and GWS. So UWS, trying to remember what the acronym stands for the benefit of the public. Universal Waste Systems, and the other is Greenwise Soils Technologies. So Greenwise Soil Technologies, they do the composting in the green waste diversion, and it's made into compost. And so the residents believe that at least the complaints that we're receiving is coming from the composting facility to the west of them. And so we're trying to follow up to verify those complaints, because one of the things that we have to do as a city is to make sure that the complaints are verified, right, by staff. And we're in that process right now. We are in touch with South Coast Air Quality Management District, as well as the LA County Department of Public Health, because they're the ones that do the yearly or periodic inspections. So we are taking it pretty serious. And so there's probably going to be more to come, and we're going to be doing regular updates to council, but we could also do that for Planning Commission the next time.
Yeah, that would be great, because like I said, I mean, they're our service provider, and I think it's important for us to make sure that, because they are our neighbor, and I feel like they've been pretty active in our community, that it's good to make sure that, that we keep that relationship well. And if this is affecting the community, I mean, it's just not a good thing for anybody. And I have to say, I've actually gotten whiffs of smell and within the area, and I wasn't sure. I can't say they're from there, but I mean, if it's something, if what I've smelled being like almost half a mile away is bad, and I can't imagine if that is the same smell that the people living next door to there are experiencing. It's unimaginable. And I think I'm glad that the city's on it now, but if this is the same issue that's been going on for the past 10 years, I know that we've had a high turnover rate, but I feel like, hopefully, or I'm hopeful that there is a process for these kinds of issues to kind of keep on the purview of, incoming staff, especially if it is something that has to be reported to other regulatory agencies. That's been an ongoing problem within our Southeast LA area, and I think it's something that's really important for us, especially when things like this come up to the commission, to be aware of. But yeah, does anybody have anything else?
Maybe an additional comment. I think, and please correct me if I'm wrong, when I was looking at the city council packet, specifically around the flagpole, I think it referenced something around like there wasn't a code or a policy for a flagpole over 100 feet, that was the reason it went to city council. And if that's the case, I think it's also an opportunity for us to kind of explore, like, how do we make sure we put something in place so that we don't find other businesses deciding to put up 100-foot flagpoles at every corner because they have enough parking, right? Like, because that is, as of right now, I think that's a realistic kind of opportunity for businesses, right? So how do we navigate that? And like I said, I touched the first part because I think there's two things there, right? One is we don't have a code or policy around that, and then the other is, are we planning to do something to address that?
Yeah, so that's a really good point. The property that FHC is on is zoned IF, Industrial Flex. And so the height standard for the IF zone is 55 feet or 5 stories. And it's really meant for buildings, not for structures such as a flagpole. So that's why it's sort of like in that gray area. And we've been looking at our code, making notes in our code where in areas where we can make updates at a future time. Because I think there are some inconsistencies in there that do need to be fixed, that we need to do a code amendment on in the future, and that will be coming before the planning commission at some point. But that is another thing that we can explore also, since there is no, I guess, definite height requirement for structures in the IF zone and probably other zones as well, that maybe we can update that, just so it doesn't apply just to buildings, but for other structures.
A few other things have come up throughout the last couple of years specific to things that might not be in our code or a policy. I mean, this is your world. I think they mentioned code specifically around like murals on public buildings. We were kind of behind that where there wasn't something in place. We're like, okay, well, we don't have any discretion on that because there really isn't anything in place at the moment in regards to the approval process for something along those lines. I bring that up just because, I mean, there's also been transition within the department. So I just want to make sure I just kind of bring it to the forefront. And Greg's been the common denominator across the whole time. He's holding all the historical part here, all these conversations we've had. But I just bring that up because that's how it opens up, right? You open up a little bit of crack in the door, and before you know it, you have things just popping up left and right. And then it's like, is it in the best interest of the city? Curb appeal, things of that nature. So, I come in good in
I will say that you're right, that the guidance for the planning commission's authority over the approval of murals is sketchy at best. And then something that we do need to look at how we can give you true guidelines and true parameters without trampling people's constitutional rights or being too arbitrary.
Any other comments? No? Okay, I was going to say, is that me or you? I was trying to do the eye contact thing. Yeah, so can I get a motion to adjourn? Or that's not a thing here. Well, I'll just call to adjourn the meeting today, 7:28.
Thank you, staff. Thank you.